So when we're talking about contesting a will, there are usually two reasons why a will can be contested. One is that the will wasn't properly pulled together. There are statutory requirements in terms of the number of witnesses you need and what it's got to say to be a valid and enforceable will. And if those requirements aren't met, there could be a challenge. And the requirements don't come out of nowhere. I mean, they're requirements that safeguard the validity of that process. Another reason why a will can be challenged is if somebody believes that there was fraud or undue influence. And the common scenario there is that your loved one is being taken care of by someone who they trust. It may be a caregiver, it may be a relative, and sometimes that caregiver or relative is so close to the loved one and they start making requests and they put pressure on the loved one to give them all the property in the will. And if someone on the outside of that process has a whiff of fraud or undue influence, they may challenge the will as being procured through improper means. So when we're talking about contesting a will in probate, the first thing that happens is that somebody who has the will is required to lodge it with the court, the original copy with the court. And at some point, there will be a petition made to appoint somebody as executor of the will. And if a family member thinks that the will is invalid, that'll be the moment at which to object to the will and just say, Judge, it doesn't have the two signatures that it needs, or this wasn't notarized, or that, or the other. And so that's a moment at which they could oppose appointment of the executor because the will is not valid. Beyond that, if someone is accusing somebody of fraud in procuring the will, they'll usually file what's called a petition. They'll lay out their reasons why they believe that the will was improperly procured. If somebody used a heavy hand on the deceased or defrauded them, they'll file an outright petition to have the will stricken, and that petition will be set for an evidentiary hearing where witnesses will be listened to, and there will be a process to get medical records and review the state of mind of the deceased. There are certain kinds of evidence that is important to consider when deciding if a will was procured by fraud. One is, who are the beneficiaries? Because in Nevada, certain beneficiaries are looked at with a suspect eye. So for example, caregivers who slipped into the will at the last minute, they're looked at suspiciously, and they may have to prove that they're valid rather than you having to prove that they're invalid. Another type of evidence that's really important is medical records, specifically records relating to the competency of the deceased and also what kind of medications they were on and whether they would have affected the deceased's ability to process information. And then a third kind of evidence that is looked at is financial records. What was happening with the deceased's money? What were they spending it on? What were they doing? And what was happening? So those financial and property records are going to be important in piecing together the story. If a will is successfully contested, then what happens is that the situation goes back to how it existed the day before the will was signed. So if there was a previous will in place, then that's reinstated. If there was a previous trust in place, that's reinstated. If there was nothing in place, then there's nothing. And you'll follow the statutory laws for what we call intestate succession. And basically the statute says how property is distributed in the absence of a will. You're likely to have unique questions about contesting a will in your situation. If you have any questions, give us a call at the Sierra Crest Business Law Group.